rise. Court of Appeals, Division 1 is now in session.
Morning. Please be seated. This is the time set for oral argument in the case of Nguyen versus Arizona Department of Economic Security and Hensley and Company. Our UB number 12-0372. Each side will have 20 minutes within which to make their arguments here this morning. Appellant may reserve some portion of that. That's entirely up to you, Mr. Abney. We have read the record. We have reviewed the briefs, all briefs, and are familiar with the facts and the issues that are raised. We are recording these proceedings for our own use in audio fashion. We're also recording it on video, so if you're really interested, in the very near future, you can go on our website and watch the argument. With that, Mr. Abney.
Thank you, Your Honor. May it please the Court, my name is David Abney. I'm representing the appellant. Thank you for the opportunity to have oral argument. I'm going to use the word release to refer to the severance agreement and release. That's not a forensic trick. That's simply the way it referred to itself in shorthand. It's said to refer to it as release. The purpose of the release is overwhelmingly an exchange of money for a release of all kinds of claims, potential claims, actual claims against the company. The longest part of the release agreement is a section called release, and it deals with more statutes than I ever knew applied to employment. He's releasing all claims for those. And then every kind of common law claim you could imagine is listed there, and he's releasing those.
Rodney, let me just make sure I understand. You concede that 2 weeks of the lump sum payment constitutes severance pay, correct?
I'm not sure. There's 2 weeks there that are dedicated to severance payment, and then it says there's also this 1 year, 12-month lump sum. And I'm not sure how the math works out on that. I can't tell from the agreement what exactly is intended by that, other than you get 2 weeks of severance pay if you sign or don't sign. But if you sign, you get this lump sum payment of 12 months. It looks to me like you're probably getting the 2 weeks of severance pay, and then you might be getting the 12-month lump sum after that.
By the math, though, 2 weeks of, you received, in your estimation, 2 weeks of severance pay, and whatever number of weeks remains beyond that, you believe is not disqualifying severance pay.
That's correct, Your Honor. That's a lump sum in exchange for the release. And I say that for a number of reasons, not only because the weight of the agreement is slanted in favor of release, but when the Vice President of Administration was testifying at the hearing, the administrative law judge asked him specifically about what was intended, and he said, would it be fair to say that the employer has roughly valued the weeks beyond the 2 weeks as a kind of mutual exchange and consideration for entering the release? And the Vice President of Administration said yes. On top of that, if you go to the release itself, on pages 2 and 3, it talks about, it explains that the benefits provided in the release are the only consideration the employee will ever receive from the company for any and all claims, demands, obligations, or causes of action released in this release.
And remind me, does that provision, that's not in the recitals, but that's in the body?
Yes, that's in a section they call representations and warranties. There was some discussion about whether the fact that the language about the 2 weeks of release was in the recital section, whether that made it a recital somehow that you can ignore a recital. But it's not a recital. It's saying this is what you get. If you sign or don't sign, you get your 2 weeks of severance pay.
Well, I have to confess, I didn't fully follow all that, because it seemed to me that Mr. Yerington said exactly what is said in the recitals and said that was the agreement. That Mr. Yerington testified to that term, whether it's in the recitals or not, he testified that was the agreement, that 2 weeks would be severance pay.
Yes, absolutely, Your Honor. Yeah, and the fact that it happens to have landed in the recital is just, I think, bad drafting. It should have been in some other part. In fact, if you're doing a contract like this, you really ought to just grab a hold of plain language and set it out in plain terms what the agreement is and who's going to do what and when, and instead of all this common law drafting stuff that just confuses everybody after the fact.
Well, Mr. Abney, in that mode, concerning the breadth of the release, I think it's a factor that we should consider in these cases. But suppose the payment was really motivated by a magnanimous employer who wants to take care of an employee that he's sorry he had to let go or whatever. I mean, I could see an employer in that situation saying, well, while I'm being so generous, I might as well protect myself, and sort of a corollary or an ancillary part of the agreement that gives them some protection and release. And if you're doing a release, you might as well make the thing that works, right?
Yes, Your Honor.
I mean, how many releases do we look at that just don't go far enough to do what anybody thought it was going to do?
Right, or they're poorly drafted, yes. Well, if I understand the question is...
It's sort of a question.
Okay.
I guess what I'm saying is that I probably wouldn't find the breadth of the release a definitive factor. I think it's a factor to consider.
I agree that it's a factor. The testimony from the Vice President is another factor. The structure of the release itself, but it's not just an employee saying, well, I'm going to reward you for your past services, or I'm going to give you some money in exchange for to help defray your costs as you go forward in the coming year because you're not going to be working with me. The thing is structured in the sense that you get your 2 weeks of severance pay and then everything else is in exchange for that release. Plus, if you just say, I mean, there would be problems if you try to do what you were stating. The difficulty would be, where's the consideration for the release? I mean, somebody's going to come back later and say, well, all this was nice language, but what was really here was a release, and the consideration. You still have the consideration problem.
It might be considered as gratuities on both sides.
Yes, and here there's not gratuitous. I mean, it says right in the release, this is all you're going to get for this release.
Hypothetically speaking, don't you think that an employer could tailor a fairly narrow release without converting severance pay into, or a payment that's intended as severance into something else by, for example, releasing any wage-related claims, any benefit-related claims? I mean, this release is probably as extensive as a release could be. Do you think that's a factor that the court should consider, the breadth of the release? And I guess I'm also raising the issue that Hensley has raised about public policy. Could an employer draft a more narrow release and prevail on the argument there?
Yes, I could sit down in in a day or two, draft something pretty strong and pretty clear and protect the company. But they didn't do it that way, and I don't think they intended to do it that way. If you take what the Vice President was talking about, they intended to offer this employee, well, you've got two weeks, no matter what. You're going to get 2 weeks of severance pay. But if you want more, then you're going to have to sign this release. If you don't sign the release, you're not going to get a penny more. There's a lot of imprecision here, especially on the part of my client. I don't think he knows what severance pay is to this very day. He realized he was going to be getting something at the time of severance, and he loosely referred to it as severance pay. In fact, Section 2 of the agreement, Section 1 of the agreement has that title, severance pay. But it's not really talking about severance pay. The severance pay clause actually appears in the preceding page where it has that section dealing with the 2 weeks of severance pay. So there's an awful lot of looseness of language here, which should not divert the court, I hope, from the primary purpose of this agreement, which appears to be the release. We're all guilty of imprecision. I mean, in every law firm I've ever been at or seen, they always have a backer called a pleadings backer. And in that pleadings backer, you're going to find motions, replies, responses, as well as answers and counterclaims. And we all know that a motion is not a pleading, but we all call it a pleading. And here, if they thought about it, they would have realized and have used more precise language in the agreement itself. That's, by the way, the only time that this agreement goes off the rails and uses severance pay. It's in that one heading, severance payment, and it's really not describing a severance payment at all. It's describing the overall benefits, as it calls, that are going to be paid under this agreement, and later refers to the benefits in connection with this is all you're going to get for this release. I've sort of run out of steam. I'm happy to stand here and chat for a while, but
I only have one other question, and it's whether your tie is intended to be any kind of comment on the proceedings today.
absolutely not, Your Honor. That's a long story, but I've got extra time. I'm colorblind, so my wife picks out all my clothes for me.
House is not color blind.
I know, and I told her last night I was going to oral argument at the court and I needed a suit. And so, but when I got up this morning, I got up out of the house around 6. She was sleeping and she hadn't put out a suit. And I said, I'm not going to wake her. And so I wound up in my sort of semi-casual court attire. And I apologize for that, but I'm a great admirer of Disney, by the way. I think he's a wonderful man.
Just wait till he plugs it in.
Well, with that, you may reserve the rest of your time. Mr.
And I meant no
Abney.
disrespect for the court. I have great admiration for the court and everybody here. Thank you.
Counsel. Forward.
May it please the court, John Belitis with Fenimore Craig on behalf of Appellee Hensley and Company.
Nice time, Mr.
Thank you, Your Honor. I want to step back just for a moment and think about and ask you to consider a very simple statement that the appeals board made in its decision that is the subject of this appeal. And the statement in the decision that I want to focus on is that Arizona's employment security law controls the issue before the court. And I would like to remind the court that in 2004, our legislature drastically changed this law as it relates to severance and how severance impacts one's eligibility for unemployment compensation. And this is important because the case law and the arguments that the appellant makes are all based on the notion that severance is paid in consideration for past services. And moreover, that a contract that the parties enter into in conjunction with paying for the severance can impact one's eligibility to receive unemployment compensation. And our changes in 2004, through those changes, our legislature flatly rejected both of those notions.
It did, but it didn't define severance pay. And I respectfully disagree with your suggestion that Section 23621C resolves the question. That tells how to allocate payments, but it doesn't tell us what is severance pay. And it seems like Colorado wrestled with some of these issues and disagreed with appellate holdings and modified legislation to make it clearer that a release included with severance payment isn't necessarily a disqualifying factor. I don't see how the 2004 amendment to the statute, other than clearly saying severance pay, and a lump sum payment we know from regulations can survive scrutiny. I don't follow how the 2004 amendment answers the question.
Let me try to articulate it, Your Honor, because I see it. If our legislature says we are to treat severance pay and its implications for eligibility for unemployment compensation the same way, whether the parties enter into a contract or not in connection with the separation and the payment of the severance pay, that to me means that the analysis does not change regardless of what the contract says, regardless of whether the contract has a release or other provisions in it. You never reach the question of what consideration in the contract supports various other terms in the contract. The statute now says you engage in the same analysis whether there's a contract in play or not. And I would...
For allocation purposes, but not for defining what is severance pay.
Well, but the legislature could have just as easily said, we will treat severance the same way, and it will suspend someone's eligibility for unemployment compensation, even in the event a contract is involved. But only if the contract doesn't contain a release, or only if the severance is paid unconditionally pursuant to the contract, or for that matter, only if the contract defines we can determine the primary purpose of the contract was to replace wages. But that's not what 621C1 and C2 set up. It says if the severance is paid, even if it's paid in conjunction with a contract, it has the same implication for eligibility purposes. And And I want to,
Let me back up also, because I think I also disagree with you about what they're referring to as the written contract. I mean, the notes that accompanied the 2004 amendment, to me, make pretty clear that what they're talking about is an employment contract that existed at the time the employee is being let go, not a severance agreement, release, whatever you want to call it.
well, C1 and C2 make clear, though, that in any event, whether there's a contract involved or not, the analysis is the same.
For allocation purposes.
Well, certainly for allocation purposes. So I want to then talk a little bit about the notion of releases in contracts like this, specifically in the employment context.
Yes, this question first. I mean, your argument really is that the employer can unilaterally characterize the nature of the pay, and that forecloses our court or any court from examining what exactly is being exchanged here?
Yes, Your Honor, provided there's a reasonable basis to characterize it that way. There has to be a reasonable basis to characterize it that way. And if I can speak to your question sort of in light of the facts of this particular case, maybe I can get you the answer that you're looking to derive. In employment situations generally, when releases like this are entered into between employees and employers, in virtually every instance there's a release. And in most cases, there also is a very specific allocation of what the consideration is being paid for in that release document. Back wages, emotional distress, reimbursement of attorney's fees, and so on. The fact that a release is included in that document does not undo the parties' agreed upon characterizations of those monies. And as a practical matter, in the employment context, it really can't. And here's why.
But I'm sorry to interrupt, but didn't Hensley's representative describe in his testimony what the sums were for? He says 2 weeks of severance pay and the rest is in consideration for a release of claims.
No, Your Honor. I mean, the agreement, and I think what Mr. Yarrington said was, which is exactly what the recital says, which is you will get 2 weeks whether you sign this or not. But if you sign it, you will get an enhanced severance benefit.
Well, what he actually said was the ALJ questioned him, would it be fair to say that the employer has roughly valued the weeks beyond 2 weeks as, you know, a kind of mutual exchange of consideration for entering this release? Yarrington said yes.
Yes, and to me, Your Honor, that's that answer is extremely ambiguous. I don't know that Mr. Yarrington, by saying yes, it was a mutual exchange of consideration, is saying that, well, yes, the payment was in return for release. And here's, factually in this case, here's why I don't think it was. And it becomes clear to me when you think about this. Hensley, as I was saying before, when you characterize money in a certain way in one of these releases, in the employment context, it's very difficult to get away from that characterization based on something like a release being present in the agreement. And the reason is because many times the way that consideration is characterized has tax and withholding implications. In other words, you couldn't take the position that the release negates the parties' agreed upon characterization of the money because it would skew how the employer needs to treat that money for reporting purposes. In this case, Hensley withheld on the entire year's worth of severance. The agreement says that it will be withheld upon, and Hensley did, because it was wages. It was a wage replacement. And when the appellant received the money, he didn't pick up the phone and say to Hensley, why is my net so much lower than my gross? What did you do? In other words, to try to figure out what happened, because Hensley would have said, well, we withheld on it because we just paid you wages. And then he would have said, no, this was a payment in return for a release. It wasn't a wage replacement. You need to increase that. You need to reverse your employment-related withholding and give me, it's taxable, but you shouldn't withhold on it if it's a payment for a release.
Is filing for unemployment benefits isn't the equivalent of an indication to the company that he disagrees with that approach?
Well, no, Your Honor, because if he really disagreed with the approach, why wouldn't he have objected to the way in which the employer withheld on the money? He admits in his testimony that he got bad advice from his financial advisor. He says, I filed for unemployment compensation, but admittedly, I think my financial advisor didn't know about the changes to the law in 2004. I think he conceded at the hearing that he actually received poor advice from the person he sought the advice from. Now,
Can I ask you,
yes.
because I'm having trouble, a provision that Mr. Abney cited in his remarks, which I have found in the representations and warranties section of the agreement, says, "The benefits provided for in this release are the only consideration that employee ever will receive from the company or any release parties for any and all claims, demands, obligations, or causes of actions released in this release." To me, that clearly says that this is consideration for signing the release.
Well, Your Honor, but that was the same case with the Betcher case, for example, where an employee negotiated a settlement with his employer, and he received a back pay award and signed a document to get the back pay that included a release. And just because that individual released his claims did not change the fact that he received back pay, which disqualified.
The employer in that case drafted the agreement, say, this is the only consideration you are receiving for signing the release. I mean, I'm looking at the specific language here that Hensley drafted, which ties signing of the release to the consideration.
Well, but what is your question, Your Honor?
Well, I think that's a problem for Hensley because it's specifically saying that you're signing this release in consideration for the benefits that we're giving you.
Well, he is, Your Honor, but
And
I
for
think
releasing causes of action, it's not just the colloquial or the I don't remember how Mr. Abney described it, but they do refer to release sort of generically. But here it's for releasing causes of action, that this is the only consideration you're receiving for releasing these causes of action.
But there are 2 points, I think, that are responsive to that comment. One is the notion that I think the appellant doesn't address it in the briefing, that monies paid pursuant to release agreements can serve multiple purposes. You're never going to run into a situation where an employee signs a release that allocates money in certain ways, takes the money, and then sues the employer and says, well, but there wasn't anything in the agreement that specifically earmarked any of this money for the release. And conversely, as I said before, the existence of the release in the document does not negate the party's characterization of what is being paid as long as they have a reasonable basis for paying it that way. And so I don't know if I'm getting to your question, Your Honor, but the fact is that payments like this often, in virtually every case, serve multiple purposes when they're paid in these agreements. You don't see a release agreement in the employment context, for example, say, we're going to pay X for wages, X for emotional distress, X for severance, and then an additional X to support the release, or to support the confidentiality obligation, or the non-disparagement obligation, or a restrictive covenant. That's because the payment always in these documents serves multiple purposes. And I would, this is one thing that we did point out that really wasn't addressed too clearly, I don't think, in appellant's briefing, and that is, if you really are looking to get at the primary purpose of this document, I would consider the fact that the document tells us if Mr. Wynn breached it, the only amount he was entitled to retain to maintain the enforceability of the document was 1 month's pay.
Is it really as broad as you just stated? As I read that provision, and that's your alternate argument that if we find a hybrid payment, that's your position, but that only applies to sections 7, 8, 9, and 11 of the agreement, which are the anti-disparagement, using confidential information, retaining company property. The way you just said it sounded like it was applicable to all provisions, and I don't read it that way.
Well, Your Honor, regardless of which specific provisions it applies to, my point is that if you read the document that way, you can see that the primary purpose of the document was obviously was not to pay for a release, because if he breached different sections in the document, And as a consequence of that, he had to return a portion of what he paid.
Right, it's sort of a liquidated damages provision for breaches of those provisions, but I'm not sure how that applies to these facts, because there's no claim that he breached those provisions.
No, there isn't, Your Honor, but I guess my point is that if you look at that construct in the document, if you're trying to figure out what the primary purpose was, I think that tells us a lot about whether or not the primary purpose of the document was to secure release. I think Mr. Wynn entered into a contract in return for receiving an enhanced severance benefit. Not in return, he wasn't paid an entire amount of money that was graduated based on his years of service in return for the release. If that were the case, I would think that all of the payments made to all of the Hensley people who were separating, if the real purpose of these documents were to obtain releases, all of the payments would have been the same. I don't know why they would graduate them based on years of service, because if the release, Mr. Wynn didn't have any claims to release, but if that's really what the parties were trying to get at, why would you graduate the payment based on years of service if the release in the document was the same every single time? Besides these issues, though, I think we do need to consider the public policy implications of this. I believe that the legal analysis in terms of the fact that this consideration can serve multiple purposes is enough to affirm the appeals board's decision. But I think there are even stronger public policy considerations that the court should make in deciding this appeal. If this court rules that the existence of a release in a severance agreement is always going to negate the characterization of the payment in the agreement as severance, employers in Arizona are going to stop paying severance. Unemployment claims are going to spike, and I think you're going to shift a tremendous burden for transitioning employees into new employment back to the state and away from the employers who are currently bearing that burden significantly.
Why isn't that a policy issue for the legislative branch? And I've looked at the Colorado cases to refresh my recollection, and Pirro is the one that discusses the legislative change, where in Colorado the legislature says that including settlement considerations that are not severance allowances does not affect the status of remuneration as a severance allowance. Why isn't that a prime policy issue for the legislature?
Well, and I think, Your Honor, that's probably where you and I may depart, because the way that I read C1 and C2, and I know you disagree with me, but the way that I read it is that you, as I said before, the analysis remains the same, whether there is a contract involved or not. And there's no qualification to those instructions. It doesn't depend on whether the contract has a release or other terms in it. The analysis remains the same if there's a contract in place between the parties at the time of the separation. The other public policy issue, which is sort of the flip side of the issue relating to who bears the burden of this going forward, if you rule in the appellant's favor, is how does it affect the worker? If a release in a severance agreement is going to negate the characterization of severance in that agreement, such that employers drastically cut back on severance payments, that will shift the responsibility for covering those employees to the Department of Economic Security. And we know from this case that if Mr. Wynn had been exclusively bound to seek severance from, or to seek wage replacement, I should say, from the department, he probably would have received about $12,000. In this case, he received nearly $80,000. And the irony, I think, behind deciding that the release will negate the characterization that the parties place on severance is that it ultimately can really hurt the individual if employers scale back on their practice of paying severance, because they're not going to pay generous severance amounts in most cases unless they obtain a release in return for paying those enhanced severance benefits. That's a large concern for me, and I would encourage the court to to consider that. I don't have anything else unless you have any more questions.
Thank you.
Thank you very much.
One reason you'd want to graduate the payments over time, say that a person who's been there 15 years gets a certain percentage and somebody who's been there 20, 30 years gets a certain percentage more, is that you have faced more danger with somebody who's been around a long time. They have more invested in the company, and they may be angrier at having been let go at a mature age and not having to face the problems of getting another job someplace else. So it makes sense that you would give more money to people who've been there a while longer to get that release, to make sure that you deal with that sort of a problem. Employers are not going to stop paying severance pay. What the employer here was doing was protecting itself from potential large liabilities from all kinds of statutory and common law claims, and it was willing to do that by giving him what amounted to net pay for the 1 year, a reasonable exchange of value, which is the way the administrative law judge saw it from the very beginning, as a reasonable mutual exchange of value. As you went through the transcripts, you might notice that the administrative law judge is really trying to get both sides to put their cards on the table, and in the end he got Mr. Wynn to admit he didn't really know what he was signing, other than he was going to get 2 weeks of severance pay, and then if he signed this agreement, he would get far more. And then he got the administrative law judge to go through it step by step and say, well, what is actually being given here? Well, 2 weeks of severance pay no matter what. And then what about this extra money? Well, that extra money is in exchange for the release.
Well, Mr. Abney, what we heard was a strong point for the employer, and that is this was a situation where the employee actually was advised, not necessarily by a lawyer, but by a financial advisor. And you're presuming, or you want us to presume, that that this truly is unequal bargaining power, and that the employee did not understand and did not agree to the characterization that was foisted off on him. Now, that may be an economic reality, but I'm not sure it's there on this record.
And to this day, even after talking with him, I don't know what he was thinking at the time. He knew something was off, and that he was supposed to be entitled to get unemployment benefits despite this agreement. And that's the impression he got from the financial advisor. And many people would rely on financial advisors for far more than simple financial advice. But I still don't think he understood precisely what he was signing. It was never truly explained, and it's in the record. It was never explained. It was a take it or leave it basis.
And counsel suggests that Mr. Wynn's conduct in accepting without protest these payments that are netted for withholding is either a waiver or some concession that, or an agreement that yes, this does constitute wages.
And I understand the argument, but from the perspective of the person who's getting this, he's saying, okay, you're going to give me a 12 months lump sum less what is usually taken out. Okay, we have a deal. I mean, I'm going to get the 1 month. This is what you're going to give me, and it's, I'm going to take it or I'm not going to take it. He decided to take it, but from his perspective, the fact that he's getting a net sum doesn't seem to factor into what his understanding would be. He was going to get something far more by signing the agreement than he would get by not signing it. Which is, and the whole thing is set up that way. If you sign this, of course, we're going to give you the severance pay no matter what, but you sign this magnificent release and you get a whole lot more money in exchange for the release. You've got a bargain there. Everybody on this is a bit fuzzy, and the language in this agreement is a bit fuzzy, but I don't think that detracts from the main purpose of the agreement itself, which is to secure a release.
What about Mr. Velitis' argument that the 2004 amendment to Section 23621C tells us something relevant about how the legislature intended for this payment to be treated?
I think it intended for true severance pay to be treated in a specific way. But there again, the problem is, unlike some states, Arizona hasn't defined in the statute precisely what is meant by the term severance pay. The usual understanding is that it's a reward for past services, or it's even more often it's to ease your transition into another job or transition into retirement, if you will. But this is not any sort of traditional kind of severance pay. I mean, that 2 weeks is already dealt with. That's the traditional severance pay. This is overwhelmingly an exchange where you agree to sign this release and let go of all these potential claims, and in return you get a pretty large lump sum of money.
But the document itself, I'm sure you would agree, constitutes a contract between the parties. And doesn't that fit within the legislative language?
No, not when it's talking about the written contract. The written contract is some sort of existing agreement that you've already gotten. I mean, that's pretty clear from the statutory structure. This is a separate agreement. This is you're leaving, and here's the agreement we're going to give you. You take it or leave it, and it defines the terms that way. So this is a special deal that they reached. Oh, the Betcher case, I discussed that in the brief pretty well, in the reply brief at page 21. It's one of those cases where you actually dig into what happened and you find out it was a dispute, unfair labor practices, and the employer in the end, under an order from the National Labor Relations Board, had to agree to enter into a settlement agreement, and it did, to provide back pay. And that's what it provided. It was back pay. So, I mean, it's specified by the National Labor Relations Board and in the settlement agreement. So there's no question, I think, in Betcher, as far as what was being provided, was back pay. The one case that I found that you might want to take a closer look at is the Parker case from Idaho. The woman who signed an agreement called a general release and computation of severance benefits. And in that Parker, the Idaho case from 2004, she signed this, she got money, she went off and signed up for unemployment benefits, and she wrote down, well, I got severance pay, and she received this money periodically. And eventually the unemployment people caught up with her and said, what is going on here? And she said, well, I was entitled to get unemployment benefits, even though I received some severance pay. And by the time it all got sorted out by the Colorado Supreme Court, they said that what really happened here was a release. And therefore it was not any sort of severance pay in actuality, despite the words that had been thrown around constantly, calling this, even she was calling it severance pay, much like Mr. Wynn has done. So it's the reality of the economic transaction, I submit to the court, that should control what happens here. If there's no further questions, I'd like to apologize once more for my tie and thank the court very much for the opportunity to speak with you.
Thank you.
Thank you, sir.
Thanks to all counsel for the work on the briefs and in the presentation here this morning. Very helpful. We'll take this matter under advisement and issue a written decision in due course. We will take a short recess to allow counsel the next case to set up. Thank you.